In the aftermath of the tumultuous events of January 6, 2021, which saw fervent supporters of then-President Donald Trump storming the Capitol, significant security measures were swiftly implemented to safeguard key governmental edifices. Among these was the imposing Supreme Court building, standing sentinel across from the Capitol, cloaked behind ominous fencing. However, in a recent session of oral arguments pertaining to Colorado's endeavor to bar Trump from the Republican primary ballot, the focus of the Supreme Court appeared to pivot away from the central query of whether the events of January 6 constituted an insurrection. Rather, the justices seemed inclined towards a ruling that could favor Trump on alternate grounds, effectively sidestepping the contentious debate surrounding the nature of the Capitol breach. During the extensive 2-hour deliberation, the justices delved into an array of legal intricacies, encompassing discussions on the applicability of Section 3 of the 14th Amendment, which prohibits individuals who have partaken in insurrection from holding federal office. Notably, there emerged a discernible majority leaning towards the stance that states lack the prerogative to enforce this section, thus possibly bolstering Trump's position. The courtroom dialogue traversed diverse legal dimensions, scrutinizing whether the ambit of Section 3 encompasses the presidency and pondering the necessity of congressional intervention for its enforcement. Despite these deliberations, the pivotal inquiry into the characterization of the events of January 6 as an insurrection remained conspicuously understated. Justice Ketanji Brown Jackson emerged as a lone voice directly addressing this crucial issue, probing Trump's legal representative on whether his client's actions amounted to insurrection. However, the response vehemently rejected such a characterization, contending that the events constituted a riot rather than a concerted effort to overthrow the government. The controversy surrounding Trump's eligibility was compounded by conflicting judgments, with the Colorado Supreme Court deeming Trump ineligible under Section 3, in contrast to a lower court ruling. The latter had acknowledged the occurrence of an insurrection but deemed Section 3 unenforceable. Throughout the proceedings, palpable unease reverberated within the Supreme Court, particularly concerning the prospect of adjudicating a plethora of state court rulings akin to Colorado's, which could potentially bar future presidential candidates on insurrection-related grounds. Justices expressed apprehensions regarding the feasibility of reviewing evidence relied upon by state courts and the potential ramifications of divergent state rulings on electoral integrity. Notably, Jason Murray, representing Colorado voters contesting Trump's eligibility, underscored the gravity of the January 6 assault, framing it as an unprecedented attack instigated by a sitting president to subvert the democratic process. As the Supreme Court grapples with the intricacies of Trump's eligibility, the question of whether January 6 constituted an insurrection looms unresolved, emblematic of the profound legal and political ramifications stemming